All right, when we left on Tuesday, I said that I would talk to you guys a little bit at the beginning of class about what happened in this case and sort of, summarize the issues as well that you guys all brought up. This case meaning the Lee care and protection and criminal case. So some of you were surprised when you asked about Justin, and that wasn't in the original package. What had happened was, obviously, it was Justin's prosecution that started the ball rolling in terms of state intervention into, Lee's family. And the district, there's a provision, by the way, in 119 that the district attorney can actually be involved in the trial of the care and protection case.
As a witness?
Huh?
As a witness?
No, as an attorney.
Oh.
And the district attorney actually wanted to not only bring Justin as a witness in the Lee, care and protection case of Lee's children, but she wanted to do, the direct examination of Justin because obviously he was a young child and, the whole trauma of, having to testify against this adult, who was his neighbor, and the district attorney's office, had been involved with him, the victim witness advocates, etc. Well, all of a sudden, one day we were told that Justin and his family had moved out of state and wanted nothing to do with the prosecution. As I said in class, the DA had a null prosecuted his case. So now they had no case against Lee regarding Justin as the victim, and then Justin would have been like the key witness in Lee's care and protection case as well, because besides the hearsay stuff that you had, and Alicia and Jason recanting their alleged original story, and I'll get to that issue of the leading questions as well, there were just so many holes in the C&P case. So he was just gone one day. So that was, the one particular issue that really threw a what do you call it? A wrench into the whole business. Laura, did you have a question about Justin?
Yes.
Yeah.
Even though they weren't going to participate in the Lee family, they gave up their own prosecution as well.
They just disappeared. I mean, I'll tell you how I was involved shortly, but the district attorney's office may have known more. But all we knew is that there was no criminal case against Lee regarding sexual assault of Justin anymore, and Justin was not going to be testifying in the care and protection case. They were out of the jurisdiction and gone. That's all we knew regarding Justin. Another issue, and you guys actually brought it up, the questioning that was done, and of course that was about 20 years ago, maybe more. Interviewing techniques had just started to been, severely criticized. Right? The leading type of interviewing techniques that both Ellen and Kathy engaged in when they went to the home. Not allowing the children by themselves to be interviewed sort of correctly. In terms of neither of them were at that. Now there's much more in terms of training. People like that, how you talk to children, how you interview children, etc. Even the use of the anatomical dolls is a training in and of itself. So actually later on, when the case did go to trial and Ellen testified, testified in cross-examination by Lee's attorney was horrendous. Horrendous. She came across so badly that you basically, her demeanor and again, he really brought holes into, whether in fact the children had actually even said what they did originally. So that was another issue, the horrible leading questioning techniques of the two investigators. So I said I was going to get to role of counsel, and I actually had given you 2 articles as well to read, and I hope that you did. What happened in this case was that, so you know by statute that once a care and protection case starts, right, the court appoints the investigator, the court appoints counsel for parents, maybe separate counsel for parents. In this case, there was just Lee. Court appoints counsel for children, and you know, after Georgette and after the CPCS rules have changed and the ethical rules as well, that you may have, you know, actually separate counsel for children depending on their differing interests and so forth. So originally there was an attorney for Lee, and he was by appointment. There was an attorney for actually all 3 children. At the time, it was more, let me say that the court didn't consider so much the differing interests. You know, looking back on it, Jonathan probably should have had a different attorney than Jason and Alicia, but that wasn't the case back then. So that first attorney for the kids, now remember the kids talked to Ellen and Kathy one day, then they were brought to DCF offices, and actually the same interview was conducted almost immediately, and was at the same interview that they already had recanted. Their attorney who was appointed was asked to bring them to the district attorney's office for yet another interview. And if you remember, they were placed originally with their uncle. So the uncle brought them to the district attorney's office. The interview started and got heated and emotional, and the children ended up leaving. And subsequent to that, the uncle fired children's counsel and hired a private attorney for children. Okay, so there was a big to-do in the court as a result of that. That, you know, the uncle's the father's brother, blah, 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 and, you know, who's representing who, and is there a conflict? So the court actually then appointed me as guardian ad litem for the kids. So, again, back then, when attorneys represented children, it became more of, you know, the child's counsel sort of being this like, and I talked about it in my article, this champion that was going to, you know, do what was right for the kids. And that sort of role has evolved over the years in Massachusetts. Back then, there was no committee for public counsel, for example, that trains you to take cases like this. Now their mandate is actually a client. In Massachusetts, what we have is a client-directed model, which means that when you represent a child client, and that child client, you know, is mature, you know, is able to understand the process and what's going on, that just like an adult client, that person is directing the course of the representation. I wanted to say something, and I was looking at the article. I'm sorry, I forgot. If the ethical rules in Massachusetts are in line with what we call a CPS standard, the Committee for Public Counsel Standards. Say you have a child who really can't make what's called an adequately considered decision. The child's too young. For example, Jonathan, clearly, he was 4 years old. He didn't understand what was going on. So again, in Massachusetts, the role that you take when you have a child client like that, again, is not a best interest role. That's for GAL, that's for guardian ad litem. You substitute your judgment. And the basic question that you ask yourself is, if Jonathan was old enough and mature enough to understand, right, what would he have wanted? What would his wishes have been? So you seek to try to figure out, you know, by observing the kid, by looking at things, by looking at the family, by seeing his interaction with others, whatever. By knowing, and as an attorney, not only going to the legal conferences, but kind of understanding as well child development and issues like that, biology, neurology, again, trying to figure out what that child client wants. So let me get back to Alicia and Jason. So Alicia and Jason were not only adamant that this didn't happen, and what really happened was this, we'll call it a shower incident. That unlike many of the care and protection cases where the child is identified and then really has nothing to do with the case, because it's very traumatic for the child, you know, to be in the courtroom in these cases. They not only were, and don't forget, they weren't in dad's custody, but they were brought because they wanted to every hearing set right up front with their dad. To, again, this show of trust, this show of loyalty, family loyalty, etc. Yeah, at one time, DSS, they were called DSS then, actually, you know, tried to get their counsel off the case, you know, saying, you know, alleging that the counsel really was acting inappropriately, and that's what people think on the face of it.
By allowing was acting inappropriately by allowing the kids to sit with the dad? Yeah.
By sort of advocating against DSS, actively advocating, and if you look at this from the outside, you say, oh, that's horrible. You know, all these horrible sexual allegations, etc. And you know, you're their attorney, and you want them to go back home, etc. But here's the way you want to look at it. Originally, I drew this triangle on the board: child, family, state. If Alicia and Jason are expressing this desire, as uncomfortable, awful, unpopular a viewpoint it is, if the attorney doesn't get to voice it on behalf of his client, the judge never gets to hear it, and really never gets, you know what I mean, to hear all of the case itself. And it can become like, you know, your attorney representing, especially in a case like this, you say, oh, you know, am I wrong to do that? And it's kind of similar in a way to the criminal defense attorney, right? Representing, you know, the defendant charged with, you know, heinous crime, etc. You have to take your emotionality out of it. And it's very hard to do so. It is hard to do so. But the representation of Alicia and Jason was adequate in terms of what, you know, they, again, client directed, what they were directing their counsel. Now, luckily, you know, we also had a judge who back then was just phenomenal and understood, and on his own appointed me. Because when you think about it this way, so say you're the attorney and you're like, okay, but somebody should be around, somebody should be, well, okay, I withdraw. If I withdraw, somebody else is going to get the kids and be faced with the same predicament. So I shouldn't do that. Can I ask for a GAL myself? Well, that kind of raises attorney-client confidentiality issues as well. Well, counsel, why do you want a GAL appointed? Oh, because the kids are saying they want to go home, and I think they were sexually abused. So those were some of the issues connected with the case, and is, you know, children's counsel in many of these cases, you may be, you know, faced with similar kinds of issues. And, you know, the role of counsel from day one when the juvenile court started, even until now, is still kind of fought over by people. For example, when CPCS, Committee for Public Counsel, came about, early 90s maybe. So before then, the court just appointed you and you had to figure out what to do on your own. So they came up with, you know, rules and trainings and so forth. And so you had attorneys that had been practicing, like me, you know, before they started with all their rules. So they came up with this rule, that child's counsel should visit their kid minimum every 3 months. Next thing I know, and I'm out of it because I've stopped doing it, but you have these older attorneys that are really upset by rules like this. Why do I have to see this infant? I can figure out, without, what's the point of seeing an infant? So there are issues like that, that come up in terms of role of child's counsel. But that was the issue in that particular case with children's counsel. So let me see.
How did that all unfold in the end?
So who tested? What happened was when the investigators, Ellen and Kathy, wanted to testify, just like you all talked about, the objection became, hearsay. And the reason at the time that DSS was saying that they should be allowed to, and by the way, both Alicia and Jason's attorney was already saying that they're not coming to testify in the case, which was kind of weird because they were sitting there, but they weren't going to testify. The Children's and Lee's counsel, as I said, objected. DSS said that the purpose for which the investigators were going to testify was fresh complaint. Remember, we talked about at that point, it was fresh complaint, now it's first complaint. So the court, over the objection of Children and Lee's counsel, actually allowed them to testify, which really was a legal error because there was no corroboration. The victims weren't going to testify, so what was the purpose of, fresh complaint? So they were allowed to testify. You have the court-appointed investigators report. I didn't testify because I wasn't appointed as an investigator. I was appointed for the best interests of the children, and I took them to therapeutic appointments and things like that. So, as I said, the police officer, the investigator, the court-appointed investigator testified. Now, DSS, as I said, tried to call the children. The children refused to testify, through their counsel. Attempted to call father as well. Father refused to testify. And then the doctor that, the family doctor, I forget what we called him in your case. Did I give him a name? Doesn't matter. And remember that he, in the course of his experience, really didn't have that much experience with victims of sexual abuse, more with family trauma, etc. So he testified. And so the court...
Did the neighbor testify?
No, you weren't here when I said Justin was gone, out of the jurisdiction, no criminal case, didn't testify in the CMP.
Oh, I heard you say that yesterday, Tuesday. I thought you just made that up.
No, I didn't.
No, that was
and as I said, it shocked us all.
that was part of the info.
So the court, and it's now, remember that the court at the conclusion of a CNP trial, unlike say a criminal case, you're going to get the verdict, right? The judge after the CNP trial actually has, and this is really contributes to the backlog. They have to write extensively. Not only are they going to, is the judge going to maybe adjudicate children in need of care and protection, right? They have to write, the judge has to write findings of fact and rulings of law. Okay. So in his findings of fact, he referred to through again the hearsay stuff, all of the first interview, and then relates the shower incident, because remember the court-appointed investigator was told about the shower incident through the children talking to her. So that was a finding of fact. Another finding of fact, remember when Lee went to the DSS office And he started to say, it wasn't specific, remember? And he started to say, oh, wish this wasn't happening, well, just this general stuff. He equated that to, some sort of admission as well. His failure to even testify was an inference of unfitness. By the way, and I forgot to say this, so when the CMP case went to trial, criminal case was still pending. Criminal case had not been tried yet, okay? I'm trying to think if there's anything else that the trial, no, that was pretty much it. So, the judge found that there was clear and convincing evidence that Lee was unfit based on this evidence and his findings. So the case was immediately appealed. Now, in the meantime, remember one of your cases involved something about ointment?
The twin girls, and
yeah.
they had someone, yeah.
Very weird, but in this case, so they were actually at one point taken from Uncle Tony's and in the physical custody of a, quote, girlfriend of Lee's who had a young son. Well, lo and behold, didn't I tell you, that while a case like this is pending, all kinds of things can happen. Next thing you know, the girlfriend files a 51A because allegedly Lee was alone with the son and stroked him or did something to him, and then Lee said, no, I was putting medicine on him for his poison ivy. So there was another 51A, filed regarding Lee. And children were then placed, and remember, so it was family, preferred placements, and then finally they go to foster home, all three. And that was next because even, that was tough even in those days to have a young child like Jonathan and the three of them all together. So they're in this foster home. And now remember, the CNP is now pending, the appeal is pending, criminal case is pending. Well, they're in the foster home for a while. I used to visit them, blah, blah, blah. By the way, they never told me. They stuck to the second incident, but they also would say to me, because I would ask them, that even if he had sexually assaulted them, they still wanted to go home, he was their dad, etc. So they would keep sticking to this. But after a while of being in the foster home, they started to talk. And it turned out that indeed that it all really did happen. And they ended up testifying against him in the criminal case. And not only was he indicted regarding what happened in Pepperell, Massachusetts, but then he was sent down to Carolina or Tennessee, I forget where they were from initially, and received an on and after sentence as well.
He had done something down there.
Yeah, remember they had
It
moved up
started,
here?
right, when
Yeah.
they,
Yeah.
But not to another child. Not to another
No,
child.
Jason and Alicia.
Okay.
Now, I don't know if you remember, but somewhere in the packet it said that Alicia said something about returning back
From,
to her father.
yeah.
So, mother and her, now this was before Jonathan was born, no, maybe. At some point, she's with mom and Jason is with dad. And then it turns out too that her death was a car accident in which she drove onto a bridge or something.
It was like
It was never ruled a suicide, but
Probably was.
yeah. Something else, I just lost my train of thought. He indeed, by the way, had never finalized adoption on either of them. Some of you raised that question,
Oh, yeah.
right? Oh,
Yeah.
yes.
It
So,
led us to believe that there was that he had adopted Jason, but the paperwork was still pending on him.
Right. Neither was finalized. And so he had a mother that was alive, the grandmother who Alicia stayed with initially, brother and his girlfriend who was expecting at the time. At least those relatives, I can't remember anyone else, but once the children did start to talk, the family cut right off from them. So
The
they
foster
lost their own family. So that would be, their grandmother, their uncle. The good news was that that family, actually, the foster family became certified as pre-adoptive, and they ended up adopting all 3 children. So that was the conclusion, and if I don't know if there was anything else that I wanted to tell you about this case. But those were all the legal issues that were brought. Oh, yeah, I didn't make up what we just did either. At one point, they tried to do some sort of, blanket deal that would satisfy everyone. And it didn't work. And actually it was Lee's counsel that kind of walked away from it. Because, he was a great attorney too. He saw that there were so many holes in both cases that, he thought his client could, basically walk away from both. So that was tried in terms of some kind of settlement of the issues. Any questions, Laura?
Yep, when Alicia was first interviewed, they said, do you know why we're here, or something like that? She said, yes, because my father's a child molester.
Yeah.
Did that
yeah.
raise all sorts of concerns that she knew a word like that it was leading, that someone...
No, because
said,
if you recall, he was arrested in front of them and taken to Ayer District Court, to be arraigned on child molestation, basically. So the argument was, that's why she said that, and that she was angry, at the whole process. That, do you know what I'm saying? That was,
Okay, yeah.
yeah.
How old was Alicia and Jason by the time they were adopted? Was she
Alicia was
15?
13. The whole,
13.
yeah, because she was just going on 12. And he was 10 or going on 10. Now, that statute was not, by the way, that I made up. 233, 81, 82, 83 was not enacted at the time. So that made the case even, more holes. And to tell the truth, Judge Travellini, who's since passed on, he was wrong legally. He was wrong legally.
In allowing that testimony from the...
Yeah, and in adjudicating, on that evidence, sadly, we knew later on that it was, in fact, it happened. And that's what they say also about, sexual abuse, unless you have physical and corroboration, only the victim and the perpetrator really know what's going on. And intrafamily, sexual abuse has so many more repercussions and so many issues as well. So that was the Lee case. I don't want to say I hope you enjoyed it, but I hope you got something out of going through something like that.
What was his sentence?
His sentence was like 50 years, because he got on and after. He got a certain number of years from Massachusetts, but because he also did it in another jurisdiction. Yeah. And there was something else. I used to take them to, and he since died, was the Smith Baker Center, great psychiatrist doctor, great child sexual abuse expert. And he would say to me, and I agreed with it, that the problem with this case and a lot of this case is that you gave the children the chance to tell the second story. If you do it right the first time, and if you ensure them that they're protected and won't be further traumatized, etc., this case might, and in the end there was some kind of a happy ending, but there were, a couple of years of turmoil there for the children, and again, they lost their own biological family too. Well, not biological family, because it was certainly Jonathan who had nothing to do with it. You know? So let's turn to the IFA case assignment. And because I think we might run out of time, well, maybe we won't. Stephanie, you were going to play the DCF worker in the case when we do the administrative hearing. Do you feel comfortable enough if we start that you could sort of lay the groundwork in terms of the facts?
Yes.
Okay, so we can get to that maybe quickly. And John, you could just do your little piece as John Martineau, the English teacher, to just talk about, you know, TG's project that she had done. Jen, you're the school nurse, so as Stephanie is talking, maybe she's going to refer to you, you know, because you're the one that initially started the 51A. And then obviously we'll hear from the Tumas as well, and that's Jonathan and Laura. So let's try to keep this piece of it to like a half hour so we can get to really the meat of it being the arguments that you might be making, you know, using the cases.
So this is the administrative, correct?
Amanda, what did you say?
This is the administrative one, correct?
Yes,
Okay.
yes. So let me start this hearing, and let's hear first from Stephanie Tompkins, right?
Tompkins?
Stephanie Tompkins, who's the DCF worker. If you could just summarize how you supported the 51A for
Okay.
us.
So, in summary, on January 10th, the department received a call from a mandated reporter, which was the school nurse, Katie Landon. And this was a call regarding the neglect and the abuse of a 10-year-old or suspected possible neglect of and abuse of a 10-year-old student, Jamil. The investigation was conducted by myself, and I did a separate interview with the boy and as well as his sister,
Okay.
TG. And basically the accusation was there was a concern that Jamil has not been in school because he was he was sent home 3 days prior with flu-like symptoms. And once he got home, he did not show up for 3 days, so there was a concern that just checking up on Jamil. And at the time, the mother, the parent responded. They basically had not taken him to the doctors. They said that he was getting better except for his throat was still a little sore, but they said that he is continuing to be sick. On a separate interview, there was a discussion about a religious practice of the family's religion, which basically they offer up animal sacrifices, where they actually kill the sacrifice.
What type of religion is it? What's the name of the religion?
It's called
IFA?
IFA.
Okay.
And basically this practice is, it oriented in Yoruba, and people with this particular religion originated in the present-day Nigeria and West Africa, and basically their so-called high priest makes these sacrifices on the basis of giving praise to their gods, and the children as well as the adults will witness this particular sacrifice. And the concern was that this is could be potentially traumatized and puts the child at risk. They did not.
Child has not seen a doctor?
The child still has not seen the doctor.
Okay.
And And so this puts the boy at risk, and this is not acceptable. And also the animal sacrifices puts a emotional and physical risk of harm to the child, and the mother and father have no intentions of not exposing him to this risk. So we have accepted this.
So you supported the
We su-
51A?
We supported it, and we're trying to move forward with protective services for this child.
Thank you. Now, Jen, you're the school nurse. Tell me how this came to your attention.
It came to my attention when I was notified that the child was out of school for about approximately 3 weeks. At that time, I called
Had
the
you
home.
seen Jamil at any time, like when he was experiencing symptoms, or?
Yes, he had come to my office, and I was the one that sent him home.
Oh, okay, so you sent him home initially because he was sick?
He was very
And then he didn't come back?
He didn't come back.
Okay,
So 3 days later, when I still found out that he was not back in school, that's
Mhm.
when I called the home, and I
Alright.
spoke to his mother.
okay.
That's when the mother told me that he was feeling a little better, but he still had a sore throat. At that point, I informed her that the flu season was very rough, and the simple cold could turn to strep throat, and ear infections could lead to more serious symptoms.
Okay.
And she told me that she did not send him to the hospital.
Okay.
And that's when I filed the report, because they're putting him at harm's way at that point.
Okay, thank you. John, you're the child's sister's English teacher, correct?
Yeah.
So what?
Well, I became
No.
concerned with that also because of an essay that I assigned to the class in which I asked the students to describe their New Year's traditions. And when TG, the 12-year-old girl, wrote an essay about her IFI animal sacrifices, shortly after Freelander, the DCF worker, interviewed me, and I explained to her what was in the essay and the concept of ASE, where the person grows spiritually by doing good deeds, exhibiting calm behavior, and serving the gods with sacrifice. And that's how this whole thing started.
Okay. Mr. and Mrs. Tuma, would either of you like to be heard?
Yes, I'm home with my son all day. I
Mhm.
have 2 other children that I care for, so he's being well cared for, and he's not alone, and anything he needs, I give him. And part of our religious belief is that we stay calm, and I'm close to taking him to a doctor, and for all this hoopla with the school and the investigators, I need to keep him just calm, and that's how he's going to get better. We have contacted his great uncle, who's preparing for the animal sacrifice, and this will be up to the gods to help progress him, but he's not getting worse, and his sore throat is getting better. And I obviously, as my husband does, prefer that everyone stay out of this.
Yeah, absolutely. This is our belief, and we have good kids. My son's a good kid. He's a smart kid. He does well in school. My wife and I are upstanding citizens of this country, and we feel as though people should stay out of our religious belief. It's not something that I'm forced or that we're forcing my son to do. He expressed his belief in our religion, and that he himself doesn't want to see a doctor. So the fact that the school administrators are trying to force it upon us, we see it as kind of unfair.
Can I go back to Stephanie for a moment? You say in your report that the too much treatment of their child doesn't constitute what's called routine medical care under your regulations. So what's routine medical care?
Well, routine medical care refers to basic care for a child when they're sick. So there's preventative care in the fact that you do things, you take the child to physical exams and any kind of regular checkups that are required, immunizations, those are falling under that particular category. And when we refer to routine medical care, is that if a child is sick, they are within a certain period of time. If the child has an illness that needs attention, they are not to delay this particular care for the child. They are to go to see the doctor. And anything less than that would be considered as neglectful on the parent's part.
So you say improper medical care puts the child at substantial risk of serious physical injury. But what's the proper medical care for the flu? Isn't the flu usually just, rest, fluids, etc.? I'm hearing them in terms of maybe a medical doctor is not necessary.
The case, in this particular case, he had flu-like symptoms. But because the parents neglected to take the child to the doctor to be appropriately diagnosed, we feel that that is an error on the parents' part for not verifying whether or not they have the flu. If I may give you an example, there is what we call a cold virus, and then there's allergies. And the two are similar in the fact that they both have some of the same symptoms: itchy eyes, perhaps runny nose, sneezing, possibly coughing, but the differences between the two are treated very different.
Such as?
For a cold, there is rest, and you would probably increase vitamin C. But if it were allergies, that particular allergy must be addressed with allergy medication, which will help alleviate the congestion.
So can these symptoms be dangerous? Because it actually put the child in some substantial risk?
In the case of the flu could lead to other things that are more serious, as in strep throat, and as the nurse has already, and she would probably answer to this more than I, as a DCF worker. My scope is limited, but as a nurse, she's qualified more than I to say this. But she has, the child is at risk to have additional things go wrong if the medical treatment is not sought at a particular point within his not being able to be functional. And if he were having a fever, for example, that fever could lead to seizures. That fever could lead to other medical issues that could be more damaging. So by the parent delaying medical treatment, we feel concerned for the child. We do take in consideration that there are certain religious practices that they want to respect. However, when it puts a child at danger, it causes us to be in a position where that child's laws may be rights may be violated, and we have to protect and care for the children that we represent.
Mr. and Mrs. Tuma, do you have any questions, or do you understand the process that's going on here in terms of Stephanie's investigation and her substantiation, her support of the initial 51A filed by the nurse here? I mean, do you understand even any of those terms that I just threw out?
Well, as far as I'm concerned, the fact that we're being accused of neglect, that was the term that jumped out to me. The fact that we haven't called a doctor, we don't agree that that's neglect. We have my brother coming on his way to tend to my son. This isn't something that he's sick and we're just letting it go. This is our spiritual belief, and you should respect our spiritual belief.
So far, just so you know, all the department has done is supported a report that came to the department that your treatment of Jamal's illness may not be routine medical care and may constitute, as you said, some form of neglect. And the process that happens after this is the department then will, assess your family and maybe come up with a service plan.
So does that service plan include us forsaking our religion?
Good question.
It's not a matter of forsaking the religion. It would probably be seen as, if the religion puts a child at risk of serious medical injury, or perhaps even death, or a lack of having the appropriate medication to alleviate the symptoms or even address the diagnosis itself, perhaps with antibiotics per se. If it becomes a conflict between the life of a child and religious respect, then we would err on the fact that we'd rather save that child's life and protect him as an individual. He is at the age of 10, and even though you did say that he has made himself a volunteer at 10 years old to practice this particular religion, studies would probably show that at his age, his brain is still developing, and he may not be in a position where he's mature enough to make a decision intelligibly to practice such religion, knowing that his health may be in jeopardy.
So it sounds like you're saying we
I can't hear you, I'm sorry.
it sounds like you're saying we would need to forsake, you could force us to forsake our religion.
If it has to do with the health or endangerment of the child would, in our opinion, come first.
But you know that what you've done on your own is, and I assume it's because the department informed you, the 2 months, that you had a right to appeal Stephanie's support of the 51A. So the reason why you're here is so that I can hear evidence as to the determination that there was reasonable cause to believe Jennifer's initial report of neglect and abuse. So reasonable cause is just a very low, threshold. It doesn't mean the state's going to step in and take your child. It may not even mean that the state is going to mandate Jamil, going to a doctor. We don't know that yet. Okay, all we know is, again, that there was enough, at least, support at the beginning of this investigation to warrant Stephanie to conclude that Jennifer's report had reasonable cause. So that's where we're at right now. And you obviously, depending on how I decide at this hearing, you have a right to appeal my decision as well.
We are offended. As I said, I take care of other children, and their parents are very happy with the way I take care of those children. Our own children, in the neighborhood, in the community, are very bright. They're doing very well in school. There have never been any issues. And, my husband has 2 jobs, and this is our religious belief, and he's not getting worse. He's fine. He's been out of school 3 days. No one's diagnosed that he has the flu.
What, I'm sorry?
No one's diagnosed that he has the flu, and we get this report of abuse and neglect, and we're, to be honest, we're in shock. We don't know where this is coming from, and we're handling this as his parents.
All right. Is anything anybody else has to say?
I just wanted to add, from our reports, we see that the nurse reported that he had a fever, and I believe also an earache. Is that correct?
Okay.
Which that could also be, and this was diagnosed or at least assessed by an RN.
Okay. I'm sorry? Jennifer, go ahead. You can.
Who had the expertise to make such a suggestion. That
Yes.
was concerned.
My main concern is that the fever and the sore throat that he was complaining about were turned into strep throat.
Okay.
Now, strep throat is an infection of the throat.
Okay.
And the infection...
Very good definition.
The infection of the throat, the infection can move to other parts of the body. So that's why it's good for him to go to the doctor.
Thank you for your medical expertise.
I went to nursing school at Edinburgh College, okay? That's where my degree is from.
With all due respect, if you had not spoken to the English teacher, we wouldn't be here today. I don't believe we would. It's that you've learned about our religious beliefs and superimposed that on my son's illness, and that's what's caused all of this. I find that very unfortunate.
Thank you.
You can go now.
So, of course, if you turn to page 4, the hearing officer, me, I decide, quote, is reasonable to believe lack of routine medical care puts a child at substantial risk of physical injury, worsening, as you guys just said, fever, ear infection, strep throat, constitutes physical and emotional impact as defined by the department regulations. So when the tumors do just like the plaintiff in Cobble, now they appealed the administrative decision of DCF. And now it goes to court, Superior Court, and they file a complaint under the Administrative Procedure Act, which is called the 38 complaint, it's Chapter 30 of the Administrative Procedure Act. But we'll only talk about now the judge hearing legal arguments, not particularly evidence. And I've asked Amanda, what happened to the other Amanda? Amanda and Jim represent the department. Nicole, Joe, and Mike represent the parents. So let's go with counsel for the plaintiff here, for the parents, who are the ones to start first. Nicole? Okay.
Good morning, Your Honor. I represent Mr. and Mrs. Truma, who are here also with you. I first wanted to bring up that Mr. and Mrs. Truma have been taking care of their son. They are not leaving him alone. They're not making it so that he has no help. They are doing everything they can according to their religious beliefs and taking care of their son the best way they know how. Now, since it's different than what's considered normal here, going to the doctor and getting a prescription or whatever, we shouldn't judge them based on the fact that, they have a different belief on how to get better. Different case law that we'll present you with today also.
Before you start with the case law, so what standard should I be following in terms of reviewing this DCF decision to support the 51A?
Well, there is the test of rational probability, and there's also 3 balancing interests that the court needs to take into consideration today when...
Well, this is a 30A complaint petition, right?
Yeah.
So for me to overturn a department decision, and Mike has his hand up right away.
If it's not supported
Joe
by
had his hand
substantial
up.
evidence.
What?
That's the test of rational
Substantial
probability.
evidence of a substantial risk of harm.
You're both moderating, but
If it's not supported by substantial evidence.
okay, so it's the substantial evidence standard, you're correct. But what does that even mean? What's substantial evidence or not in this case?
That's also referred to in the test of rational probability. I'm assuming they're tied in together.
Okay.
But
Where are you reading from?
I'm reading
So-
from the Cobble
What case?
case.
The Cobble case? Yep. Okay.
So it defines substantial risk as I'll just directly quote it from the, it says, but whereas in this case there's no, okay, that's not explained. There needs to be a substantiated claim of actual physical injury. A finding of abuse needs to be predicated on there being reasonable cause to believe that there's a
Yeah.
substantial risk. Okay, so in order to figure that out, you need to have a collection of facts, knowledge, or observations which tend to support or are consistent with the allegations. So a substantial risk is basically stating that this child has a high chance of being harmed in the future from them not finding their doctor support or whatever, or from them finding doctor support.
So how is there, you represent the parents, how is there a lack of substantial evidence in the record?
Well, first of all, he's not suffering from a condition that will kill him. If he was going to get worse, he would.
Yeah, but that's not the standard.
Well, the standard is if he's not able, if there's a life-threatening condition.
That's not the standard either. I'm reviewing the support of a 51A, very low threshold. You just said it was reasonable cause. I'm reviewing that under the substantial evidence standard, sure. So I'm reviewing what the administrative officer heard as she reviewed the DC, the 51B investigators' finding of reasonable cause to support the 51A. Joe? I'll come to you.
I was just going to say that the social worker in this case, her findings were based on uncertainties, a heightened risk of injury created by his condition, and a risk arising from the family's practices. And those aren't things that can be substantiated. She herself said that it was not a medical emergency, and in fact, Jaleel might have even been getting better because his sore throat went away.
Okay. Michael, were you
I
saying the
was
same
going to
thing?
say, there was evidence that the child is getting better. You know, he hasn't been cured of the illness within 3 days, but he is getting better. And the concern on the part of the department is based on things that may happen, could happen, but there's no definitive if they don't do this, it will happen. And, you know, weighing that against the fact that the child is getting better and that the parents and all other accounts are good parents with good children, that there was not substantial evidence to move against the parents.
Nicole?
I'm going to keep going back to what I just said, that they need evidence in order to prove that he has a life-threatening illness, that this could turn into a serious injury in the future.
But let me just ask you a question. I just want to, when a DCF worker substantiates or supports a 51A report of abuse and neglect, does it always have to be life-threatening? Because you're making it too hard on yourself right now.
I'm
Right?
saying no.
Okay. Joe?
I was going to say that here, there's evidence that detracts from the supporting evidence's weight, so therefore it should fail judicial scrutiny because it's not reasonably probable that substantial harm was going to result from what the Tumas were doing or not doing.
Let me hear from the department.
I thank James Connie for the department here.
Yes.
Your Honor. I think, and this is more of a close case, and I think under Quabble, the court had substantial, or it stated in substantial evidence testing, accords an appropriate degree of judicial deference to administrative decisions, ensuring that an agency's judgment on a question of fact will enjoy the benefit of doubt in close cases. And you know, we can argue back and forth, but this is I believe it is a close case. The right of the parents to practice their religion versus the right of the children and to ensure their safety. And I think that we have met the burden because there is a substantial risk of harm. The boy's age, his condition, his flu-like symptoms, and the fact that this is an epidemic flu season. It's not a regular flu season. And because he has not received the medical attention, we're not even able to say with certainty that he has received the flu. He could have obtained some type of illness due to the ritual that has occurred. So we certainly are not in a position that we want to permanently remove the children from the home, but we're looking to have the child evaluated by a doctor.
In the Cobble case, the 51A was supported, and just like the plaintiffs have done in this case, the plaintiffs took it to the fair hearing for the department, and then, you know, appealed to the Superior Court, and, you know, ultimately the SJC. But in that case, the department actually had, you know, once the department had supported the initial finding, of abuse and neglect. Didn't the department offer services and Cobble said, oh, no thanks, and then the department just closed the case?
That is true.
So you're saying something different here.
Correct.
Why?
The child is still sick, even though the parents are saying his sore throat's getting much better, they're still neglecting to look at the fact that he's still running a fever and his left ear is bothering him, which is an indication of an ear infection, which could be a result of the flu.
So if the parents are unwilling to work with the department, and it brings us to the third scenario that I thought we would have time for, but we will, is the department, and now Nicole, you can get to what you, when I cut you off before. If the department now files a care and protection case alleging the child Jamil now is, under 11924, without suitable parental care, what arguments would the state and the parents and Jamil be making? Why are you smiling, Amanda?
Oh, just Joe.
You want to say something?
Oh, no,
No, all right.
May I
Stephanie,
ask
it's a
a
question. Okay.
Would it be appropriate at this point to bring out that upon the interview, with the social worker, with the parents, they indicated that because of their own religious practices, they don't use the traditional methods of.
Right. And so now you're getting into some of the other cases that you guys read. So you have the custody of a minor cases with the parents of Chad Green, who had leukemia. Now, that case was actually a care and protection case. Then you had Macaulay, where the hospital was, the petitioner sought treatment. Then you have the criminal case, Commonwealth v. Twitchell, where the parents did fall back on not only their 14th Amendment due process right, but they were also Christian Scientists. And there was a statute in that case that actually allowed them to use prayer, and they did, and the child died, and they were criminally prosecuted as a result. So let's talk about this case, the Ica case, in the context of those cases. So suppose the department does, file a C&P. Suppose he's not getting better, the department runs into court and files a C&P, not necessarily to take the kid away, right, but to get the treatment, as in the custody of minor cases. So and now we can involve everyone here. What arguments would you be making for the state, for the parents, and for the child? Again, using the role of counsel perspective as well. Anyone can start. Now this is fair game.
My argument would be that the child is at risk or harm and is in need of necessary
As the
proper care.
department,
As the
okay.
department. Is in need of.
So use some of the cases that I just mentioned.
Yep, so custody of minor.
Mhm.
The child is at serious risk or harm and is in need of necessary and proper care, and the parents are unwilling to do so.
So now I go, I'm gonna do a Nicole now and say, well, wait a minute, that in that case, that kid had leukemia. What Jamil has is not right, is not life-threatening.
We don't know what he has. He didn't go to the doctors. We have no idea what this is.
Nicole, go ahead.
If it was life-threatening, he would be getting worse. And his parents have already stated that he is getting better.
They
And
stated that
only-
his throat was getting better.
So what are the, if you're looking at, Macaulay and custody of a minor, what are the factors that the court looks at? Are you going to recite them for us?
I'll do Macaulay. Macaulay, they had done something about a best interest test for the children.
Mm-hmm.
And basically, what would benefit the child in the long run. And in this case, the child was 8 years old. She was, diagnosed with leukemia. The parents were Jehovah's Witnesses, and they did not want her having any kind of blood transfusion. But that was the only way
So what were the factors that the court looked at?
Well,
At least in the support of getting the blood transfusion in that case?
the major fact that they seemed to focus on most was that the chemotherapy was the only way for her to get better.
No, you just mixed up. You said Macaulay, but you were talking about custody of the minor.
No, I was talking about Macaulay, she was talking about custody of a minor.
Well, Macaulay's blood transfusion.
Yes. Oh, sorry. Yes.
Oh, I'm sorry. So you're talking about blood transfusion as well as chemotherapy?
Yes.
Okay, I'm sorry. Go ahead. Yeah. I got you.
And they basically stated in both cases that if that type of medication or doctors or whatever is the only way the child will get better, that it needs to happen and the judge can order that it does happen. But also in the care and protection of Charlene, it states that the court does not decide what is necessarily the best decision.
Right.
Rather, what decision will be made by the incompetent person if he or she were competent. So while this child was in a coma and she was not competent to make her own decisions, this child is competent. So, you know, the judge...
So that's
really-
one issue to be weighed in
Yes.
this case. Jamil is 10,
10
you
years
say?
old.
Okay. What about the risk to health and life that the courts talk about?
If it's substantial enough, the court can...
So here's my question. So in Twitchell, when the Twitchell's son started getting sick, you know, they didn't take him to a doctor, and, you know, they had the Christian Science practitioner. It turned out that he had a bowel obstruction, and in the end, that's what killed him. But similar to, you know, what the department is telling me is that you don't know what really is wrong with Jamil. So that ultimately, when the Twitchell's, you know, son died, when do you sort of cross the line of when the state should be stepping in and, you know, making sure that, you know, the traditional Western treatment is required in a case like this? Do you see how tricky it might get? Because we don't know with Jamil what he really has, other than, you know, a sort of a set of symptoms. But at the same time, you have the parents that not only have their due process right to not have the state intervene, they're good parents for, you know, all other reasons. And on top of that, they're fervent in terms of their religion, as is Jamil. So these are some of the tough, really tough cases. Joe?
No, it doesn't really, it's not on topic. I was just kind of suspect of the social worker's report, just because she had mentioned that the rituals such as the sacrifice might have an impact on.
Okay, we all sort of make faces when we hear the word sacrifice, but many of you are Christians. And what is the major holiday of Easter is nothing more than sacrifice, isn't it?
I just felt it seemed kind of discriminatory, maybe, you know, just to say, oh well, that their rituals might have a risk on his physical harm when it just, you know, it just seems kind of that she didn't do her homework.
Would you feel the same way if that sacrifice were a human being, as some religious?
I don't think it would make his flu worse.
Oh, you're really taking this all the way.
I don't know how that
No,
would make
it's
his
like-
any more sore or, you know, exacerbate any sort of.
If you had more time, I'm passing this book around on iPad, and it's not at all like that at all.
I mean, I would argue it, to me, when I read the case, I don't see it as a whole lot different than children that grow up on a farm that are routinely see animals
Right.
killed. I mean,
Yeah.
it's for a different purpose, but, you know, I mean, we raise turkeys and chickens. I don't have any right now, but, you know, my children have seen chickens butchered.
Did you find out?
Now,
You know, like,
Yeah, so what the department, we're running out of time, so I just want to make sure that, so what the department has to be careful about is, you know, they have their regulations that actually talk about, you know, so what is routine medical care and whatnot. So it could be, and that's what I was trying to tell the Tumas when we were enacting the fair hearing exercise, that it's nothing more than, you know, a support of, a report of, you know, reasonable cause, remember, very low threshold, and it might be like, as in Cobble, the department doesn't do anything after that. But of course, what's the reason why Cobble took it all the way to the SJC?
Because what if they do?
No, as I mentioned in Cobble's case, the department closed the case. So why did he spend on, now remember that, you know, except if there was a care and protection case, these people don't get attorneys for free. So Cobble took his case from the fair hearing to Superior Court all the way to the SJC. What I'm saying, what's the point? What? It's still a finding of abuse, which means what? For the parents. What does it mean?
It hurts your reputation. It goes against your...
Okay, but it's something more specific than your reputation.
Fitness as a parent?
No, because you haven't gone to trial yet. Where are you? Who knows about this? Who knows that Mr. Cobble or the Tumas, that there's been a support, there's been a 51A, 51B investigation and support decision, because the department closes the case.
Community.
You're in the central registry. You're in the central registry, and you're there. I forget how long it's in one of the sections of 119 that I gave you. That was exactly why he went through the time and expense. Get me out of that list. There could be another 51A later down the road. Okay.
It could even affect job, like getting a job or
Working with.
working with children.
And of course, when it gets to the point, as with the cases that you're looking about, much more serious, either the department or another entity, like the hospital here, is seeking to do something, you know, over the family's objections, but for the welfare of the child. It goes back to, you know, the Prince v. Mass case, you know, the earlier cases that we read when we first started. The state having a right to protect children. And the courts talk about not only the state's right and obviously the preservation of life, but they talk about the integrity of the medical profession. So they really look to, you know, again, you know, Western medical science, while in a way a little bit, you know, discounting. So for example, the Greens in custody of a minor, they weren't asserting any religious interest. However, you know, their son Chad Green had leukemia, so that was the custody of minor first case, and they had actually discontinued it. He was on remission for a while. They had discontinued his meds. Then the leukemia reappeared, and actually, in your second custody, when the leukemia reappeared, that's when the department sought to have custody, you know, to force the treatment, and that's the case that went to the SJC. Well, after that, the parents somehow found out about this other kind of therapy, Laetrile, which was something to do with almonds and peaches, and so it was like an unconventional type of treatment. But they're arguing, you know, parental rights. We have the right, you know, leukemia. I've had a niece that went through leukemia starting at 4, and I've seen, you know, the treatment sometimes is worse than the cure. So, you know, that was their argument. If chemotherapy and radiation and this and that and blood transfusions, et cetera, we want to try something that's more natural. Of course, you know, it didn't work. In fact, your Green v. Truman case was them again actually trying to bring a civil rights action, you know, arguing that chemotherapy wasn't, you know, the only treatment. It had a sad ending. They ended up fleeing to Mexico with him, and he ended up dying. I forget how old he was. So those are some of the arguments that are made back and forth, you know, from parental rights advocates as well as state advocates. And when we come back, you only have class on Tuesday. I'll figure out what to do with you guys on Thursday, but you don't need to be here, because I won't be here that day. So we're gonna start the adoption cases, so make sure that, you're looking at the new syllabus that I had handed, that I had handed, no, I didn't hand it out, that I posted, right?
You emailed it.
Yeah.
I emailed, and it's also on the, posted on the faculty site. So we're gonna start with, termination, that we kind of already have talked about, and you already know the standard for that. All right, have a good break, everybody.
It was interesting reading these cases because my father, when he was a kid, my